Disclosure report on political party funding, the IEC, the Electoral Commission, says it notes the general appreciation expressed at the report. The report was published after the requirements of the Political Parties Funding Act. The Commission says it thanks political parties that have complied with the law. Sai Mamabolo is the IEC CEO. He joins us now to talk about it. Thank you very much for speaking to us, Mr. Mamabolo. So I understand that the need to disclose is 100,000 rand and over, but you say it is apparent from the public discourse that a few matters require further clarity. What leads you in particular to say that?
No, we're saying that having monitored public discourse, insofar as it relates to the number of political parties that have disclosed, and certain misconceptions about the prescripts, in particular the Political Parties Funding Act, and what its provisions indicate. For instance, there's a perennial complaint that the EFF has not disclosed. Now, it is at this stage the Commission can't investigate that issue, because the party funding disclosure arrangement is a two-phased arrangement. Firstly, it's the voluntary disclosure by the political party on a quarterly basis, and then for the Commission within 30 days thereafter to then issue the disclosure report. Now, the second phase relates to the auditing of the books of a political party by a person who's an auditor and registered as such in terms of the Audit Professions Act, who must look into the financial statements as well as the books of accounts of all registered parties, and then express an opinion whether that party has conducted its financial affairs in accordance with the Act, and in particular, whether all disclosable donations have in fact been disclosed to the Commission. At that point, if such is reported to the Commission, then processes of compliance can then take effect.
I mean, at some point, the EFF said it had not received anything above that threshold, therefore it does not need to report. But if one looks at the cumulative amount, does that matter in terms of how the party was able to fund its campaign or its business dealings, as it were, just to function as a party? And I also want to talk about the ANC, for instance, the fact that it received a donation from its investment company, Chancellor House. Some say that this is possibly a way of bypassing the rules if it's using this vehicle to fund the party.
Look, here are the legal principles. One, the 100,000 is a cumulative 100,000 in any financial year. So if somebody had given you a 50 grand in the first quarter and another 50,000 in the second quarter, as soon as you reach the 100,001 threshold, that donation is now disclosable. So it's you take into account the aggregate over the year, over the financial year. And at the point it hits 100,001 cents, the disclosure requirement kicks in. Now, the Act also deals with prohibited donations, and they are broadly four. One, it's foreign government and foreign government entities. Then it's foreign persons, as well as foreign entities. And then thirdly, state-owned enterprises, as well as all other organs of state. Those four categories of institutions are prohibited from making donations to the party. No other prohibition in law exists. So that's the context within which one has to see the Chancellor House donation.
These donations, does it include in-kind donations when you talk about those that are prohibited from making donations to political parties?
Yes, in the Act, the definition of a donation includes in-kind donations. Those may be properties, those may be making payments on behalf of a political party. There are very different permutations of in-kind donations. Those must be disclosed as well.
I mean, you spoke about the EFF's failure to disclose, according to observers. There's a Freedom Front Plus as well that's also been singled out for this.
No, look, it is so that we've not received any disclosures from those parties. And it is our hope that, in fact, there are not declarable donations made to those parties, or that they've received declarable donations subsequent to the closure of the quota, because we will still need to issue a third quota report and then ultimately an annual report. We hope that if they, in the meantime, have received declarable donations, then they will act in consort with the provisions of the law and make the disclosures.
Are you, as a commission, empowered to probe non-disclosure or force political parties to disclose?
We are compelled to investigate instances where there are complaints supported by requisite evidence that Party A has received and has not disclosed, or something to that effect. If there's a formal complaint laid with the Commission, supported by relevant prima facie evidence, then it's incumbent upon the Commission to investigate. However, it will be very difficult for the Commission to investigate purely on conjecture and speculation. There has to be a formal complaint lodged, supported by the necessary evidence.
Just speaking about the two phases of disclosure, which you mentioned earlier on, parties are also, I understand, compelled to furnish you with audited financial statements. Would that be by an independent auditor, or can the party have their own auditors, submit the papers?
Well, it has to be an auditor registered as such in terms of the Public Audit Profession Act. So these are professionals who have to exercise professional judgment and do so independently. If, for instance, it's an auditor who then misrepresents the report to the Commission, very severe repercussions will result in that case, because they can be debarred from practicing as such, and in fact they may be charged for fraud, for furnishing a report that is not reflective of the true position of the financial affairs of a political party.
So finally, Mr. Mamabolo, come end of year, you say that is when the public can expect to hear from you on who's disclosed or failed to do so. Are you then able to talk about provisions for criminal or civil sanctions?
Yes, indeed. The Commission can approach the Electoral Court for the imposition of civil sanctions, in particular administrative fines. The court can mete out sanctions up to 1 million rands. They can impose sanctions of close to 1 million rands by way of administrative fines. And certain of the transgressions in the Act are in fact criminal offences. And upon conviction, a person may be sentenced to a period of no more than 5 years, including a fine.
Thank you so much for your time. IEC CEO Sy Mamabolo, just on that conversation that's been doing the rounds and the public